Particular welcome to our speaker, who is going to be talking about labour law under a Labour government, a report which John has co-authored. John has extensive experience of working in the field of labour law and advising trade unions in this country, and I think without more ado we'll ask John to give a talk. We'll then have questions and a discussion and try to keep it as informal as possible.
Great. Well, thank you very much for inviting me. It's a great pleasure and honour. I'm a very poor attender at this branch. In fact, this is actually the first time, so apologies for that. I want to talk about this book, Rolling Out the Manifesto for Labour Law. So let me just give you a little bit of context. I'm a barrister. I spend most of my time representing trade unions. In 1989, I and some colleagues set up a think tank called the Institute of Employment Rights, which is a think tank for the labour movement. It is funded principally by trade unions, but it's also got academic labour lawyers and practising labour lawyers as part of it. And we thought at the time, at the height of Thatcherism, where her policies on labour law were so heavily influenced by the product of right-wing think tanks, we thought it was about time we had a think tank on the left to put forward contrary ideas to try and redress the balance of ideology in the sphere of labour law. Well, for the best part of 30 years we've had no impact whatsoever with the governments of the Conservatives and the Labour, then the Coalition and so on, of course not interested in reform in any way at all. But in 2013, myself and a colleague, Professor Keith Ewing from King's College London, wrote a booklet for the Institute called Reconstruction After the Crisis, a Manifesto for Collective Bargaining. And in this we try to argue that one of the crucial factors to redress the balance at the workplace, which I'll say a word about in a moment, one of the crucial elements is restoration of collective bargaining. That's to say, bargaining between employers on the one side and unions on behalf of workers on the other. Well, we developed that a little bit further in 2016, after Jeremy had become elected leader of the Labour Party. With some 19 labour law experts, we published a Manifesto for Labour Law towards a comprehensive revision of workers' rights. And this sets out principles on a wider basis than simply a restoration of collective bargaining. It deals with a whole number of other things, which I'll mention briefly in a moment. Many of those ideas were picked up by the Labour Party, where obviously there was dialogue with the Labour leadership, picked up in the manifesto for the June 2017 election, for the many, not the few. If you look at their 20 points, pages 44 to 54, you'll find that many of the ideas are there. So what we've been working on since, we've now grown, I think, to 23 professors of labour law and academics. What we've been working on since is the kind of legislation which an incoming Labour government would need to pass in order to have a radical transformation of the workplace. And that's what this book is, Rolling Out the Manifesto for Labour Law. Not a very catchy title, I accept. But this is not the sort of thing that the average punter is going to read on the doorstep. But I do think that it's important for everybody, all of us who are going to be knocking on doors at the next election, to understand what the purpose of what the arguments are in favour of what I hope will be, of course I can't speak for the Labour Party, but what I hope will be the incoming Labour government's programme for labour law. Now, Rolling Out the Manifesto, as you've seen from the flyer there, covers a whole range of things, and we haven't got time this evening to deal with all of them. I'm very happy to answer questions about some of them in a minute. There's some areas that I'm really pretty weak on, but others I'm a bit stronger on. Anyway, I'll just touch on some of the major headings. It deals with I suppose the first and fundamental change is the creation or recreation of a Ministry of Labour or a Department of Employment. Do you know we're the only country in Europe, one of the only countries indeed in the world, that doesn't have a ministry devoted to labour? And that's absolutely crucial for many, many reasons. I'll just give you two. One, it gives workers a voice at the cabinet table. And two, it carries out the exercise of planning. And planning is a crucial aspect of a left-wing government. Planning to deal with the problems of skill shortages, of skill surpluses, of planning an industrial strategy more generally. So that's one element. Another element is one that's very topical at the moment. In fact, I've been involved in several cases which touch on this, and that's the problem of worker status. As you probably know, there are three different kinds of worker. There's the genuinely self-employed, there's the Limb B worker, and there's the genuine employee employed under a contract of employment. And the consequence of being categorised in one of those three compartments is that you get different employment rights according to the categorisation. And that's why employers like Uber and Deliveroo try and manipulate their agreements with their workers in order to downgrade the employment rights that attach to that category. That's what it's all about. So our proposal is get rid of all that. All workers except those genuinely in business on their own account, like barristers or pub owners who are actually owners, or cab drivers, or plumbers that have got a white van and go from one job to the next, so genuinely self-employed. All but they will be simply classed as workers, and all workers will have all employment rights from day one of their starting work. So we deal with that. We deal with changes to equality legislation at work. We deal with changes to health and safety law. We deal with workplace directors on company boards. We deal with outsourcing and supply chains and so forth and so on. We can talk about some of these things after. But the principal proposal in here is a return to sectoral collective bargaining. Now, this is a concept that needs explanation because in the old days, 40 years ago, most workers were members of a trade union. I think the height of it was in 1976 when there were, 12.5 million trade union members in this country. That's fallen to about 6 million today. And people who were trade union members understood the notion of collective bargaining. They understood the notion of bargaining over terms and conditions at workplace level, at enterprise level, or at national level. But nowadays, that knowledge has gone, particularly for young people at work. So let me just explain what sectoral collective bargaining is in a couple of sentences. It's bargaining between representatives of the workers through their trade unions on one side of the table and representatives of the employers, all the employers, in a particular sector of the economy. So, for example, agriculture, where we had sectoral collective bargaining up until 2013 when the Tories abolished it. Or the new sectors that are emerging now, like gig workers, delivery riders and so on. Or catering or fast food that used to be subject to collective bargaining on a sectoral level, but has all gone 30 or 40 years ago. Social care, for example, adult social care. In fact, the Institute published a book, 8 Good Reasons Why adult social care needs sectoral collective bargaining as a means of determining the terms and conditions for care workers who are isolated, and everybody in this room knows the conditions under which they work. They have to pay for their own cars, their own petrol, they travel in their own time, they get 15 minutes to get their old person out of bed, dressed and fed in the morning. Anything else is all in their own time. This is crying out for regulation. Sorry?
It's the bus they get in London.
Right. This sector, like many others, is crying out for regulation, but regulation by negotiation rather than regulation by legislation. So that's what we're looking for. And I say restoration of sectoral collective bargaining because that's what we used to have. That's what we had in this country. And the figures are quite staggering. In 1979, when Thatcher came to power, 82% of British workers had their terms and conditions of employment regulated by a collective agreement, mostly by sectoral collective agreements. That percentage now is just over 20%. Now just think about that. It means that only 2 out of every 10 workers has a union negotiating their terms and conditions. The other 8 are at the mercy of the generosity of employers and the forces of the marketplace in determining what their terms and conditions are. And most people's experience of getting a job is walking in, if they're lucky enough to get an interview at all, is walking in and being told what the terms and conditions are on a take it or leave it basis. If you don't like it, go away. So that's the problem with the collapse of collective bargaining in this country that we need to restore. And that picture of extensive collective bargaining, which was built up during the 20th century, really from 1909 right through until 1980 when Thatcher started to demolish it, that decline has continued in a almost continuous graph downwards. It's true that the Labour Party under Blair in 1999 introduced a recognition procedure, but what's significant is that the graph did not rise again in 2000. It just stayed stationary for 1 year, and then the slide in collective bargaining coverage continued thereafter. So the plan is to restore that, and this is a model which of course is very familiar in other parts of Europe. In France, of course, collective bargaining coverage is about 96%, and that's something that Macron is currently engaged in a life and death struggle with the French unions to destroy. In other countries like Austria, it's 98%. The general average in Europe is something over between 60 and 65% coverage by collective agreements. So we're not suggesting something revolutionary here. We're simply proposing a return to in particular, the post-Second World War settlement of industrial relations. And what I'd like to do now for my remaining minutes is just to put forward to you a series of points as to why this is important. The first reason is democracy at the workplace. Of course, worker directors are a step towards industrial democracy, something that's been debated by the Labour Party since the 1970s. But worker directors are not enough. The only way in which workers can actually have a say over the terms and conditions in which they spend their working lives is through collective bargaining, through democratically elected representatives to negotiate on their behalf what their terms and conditions ought to be. And one of the features of employment today is a lack of any democratic involvement. It's what Marx called alienation, of course. But everybody understands it. People are alienated from their jobs, alienated from their workplaces, alienated from management decisions which determine the condition of their lives, how many hours they're allowed to work, when they're allowed to work, closures of their workplace, transfers of the business, outsourcing and so forth. So democracy is a very, very important reason. Second one, of course, is one that is familiar to everybody in this room. It's about restoring, or if not restoring, at least moving towards restoration of the imbalance of power between the worker on the one hand and the employer on the other. And that imbalance of power, of course, is absolutely undeniable. In fact, in a decision last year in the Supreme Court, even their lordships recognised that the imbalance of power between workers and employers is a fundamental element in how contracts of work ought to be construed. So we're talking about restoring solidarity instead of subservience, about restoring dignity instead of deference. And that, I think, is one of the features of employment in Britain today, a lack of dignity that is accorded to workers who actually make all the wealth, as we well understand in this room. Third reason is about reducing inequality. There's a massive body of scientific evidence now, academic writing, about the consequences of high levels of collective bargaining in a country. The impact is to reduce inequality. And we know here that inequality is the blight of our society. From 5,000 people sleeping on the streets to chief executive officers earning 326 times the wage of their average employee, earning as much in a day almost as their average or median worker earns in a year. And this inequality, of course, I was just reading some statistics this morning about health inequality. Health inequality between 2009 and 2016, the disparity in health between the richest and the poorest in this country, the upper decile and the lower decile, whatever they call it, 9.3 years. I mean, how can that be acceptable? That poor people have 10 years, almost 10 years less to live their lives than rich people do. And that period of time has seen an increase of 4 months, a third of a year, of increased disparity in life expectancy. And it's true of health and many other things as well. And we've got a situation now where the median wage, as it was, I haven't looked it up in September, but in July, the median wage in this country was £23,200 a year. I mean, that is very difficult to live on. There's not much space there to go out for a meal or even go to the pictures or to go to the pub after you've looked after your children. 20% of our working population have got a median income of £15,000 or less. 1 in every 5. And of course we know in this room that there are more people on state benefits who are in work than those on state benefits who are out of work. And you can measure this in so many ways, so I won't go on and on, Richard. I know you're getting a bit agitated now, but let me just give you one more statistic. One of the ways that they measure a gross domestic product is to divide that proportion of GDP which goes in profit and that goes in wages. I know there are economists in the audience who know more about this than me, but in 1976, 65.1% of GDP went in wages and the rest went in profits. That percentage now is 49.5% in wages, and the rest goes in profits. So what we've seen over the last 40 years of neoliberalism is a decline of 15.6% of GDP being taken out of the pockets of wage earners and put into the pockets of the owners of capital. Now, these disparities have come about largely because of the collapse of collective bargaining. Our argument is, and as I say, it's supported by academic research, is that the restoration of extensive collective bargaining will diminish inequality. I don't say it will eradicate it, but it will certainly diminish the disparity between workers. And of course, we haven't got time to go into it, but I'm just talking about income disparity. There are other issues here, the difference between BAME workers and white workers, the disparity between men and women, the gender pay gap and so on. All those disparities are compressed with extensive collective bargaining. Fourth point I wanted to put before you, Richard, was this, that sectoral collective bargaining sets a rate for the job. And that means that employers cannot compete by pressing down on wages. That means that they've got to compete in other ways. That means that they've got to invest in research, development, efficiency, innovation, productivity in particular, the British problem of the moment, in order to compete. So that sectoral collective bargaining is actually very good for employers in a general way. And that setting of the minimum rate for the job has another impact as well. And that means that employers can't compete by importing cheap labour. And we know that the import of cheap labour actually doesn't have that much impact on wage levels, but people believe that it does. And that's one of the instigators, one of the motivators towards xenophobia and racism in this country. So we can eradicate that by setting the rate for the job. Fifth point is really one that probably flows from that, is that collective bargaining or extensive collective bargaining increases wages. Now, this is a country that badly needs a wage rise. People need to earn more, not just to survive, but also, of course, to stimulate the economy. The more money people earn, the more they spend. And the difference between the rich and the poor is that the poor have got no alternative but to spend their money in order to survive. Whereas the rich, of course, can sort it away in the Cayman Islands or wherever else they want to put it. So increasing wages stimulates the economy. It reduces the number of people who are forced to take state benefits in order to subsidise low wages. It pushes people up through the tax brackets so that taxation is increased to the Treasury, which means that there's more to invest in infrastructure and so on. And that argument, which is again supported by a lot of academic research, that argument, of course, is the argument that succeeded in the capitalist world in the 1930s prior to the Second World War, where Sweden, Norway, France, Ireland, Australia, Canada, even the United States in the New Deal under Roosevelt in the National Industrial Recovery Act in 1934, all implemented programs of extensive sectoral collective bargaining as a means of getting out of the Great Depression that followed the 1929 crash. And the final point I wanted to put before you, Richard, was this, and it's the one that concerns me and probably Pat as well. I don't know if we're the only lawyers in the room, probably any meeting of Labour Party, or James, any meeting of Labour Party members has got plenty of lawyers in it. But but one of the things that is important for lawyers is that the obligation to promote collective bargaining is an obligation in international law. It's an aspect of human rights. It's expressly protected by the European Social Charter of 1961, by ILO Convention, International Labour Organization Convention 98, by Article 8 of the International Covenant on Economic, Social and Cultural Rights, Article 28 of the Charter of Fundamental Rights of the EU, and so forth and so on. And Britain has signed and ratified every one of those provisions. So a Labour government implementing these proposals would be doing no more than its duty in international law. Look, I'm going to stop there. Richard, the one thing I haven't described to the audience, and perhaps we come to it in discussion, is how you legislate for extended collective bargaining. But I'll leave that for a moment. What's suggested is a more Keynesian, a more kinder form of capitalism, of the kind that was dominant for most of the last century and is still dominant in Western Europe today. So when you say, well, how are you going to regulate equality across sectors, the answer is there's nothing in here that would provide a mechanism for doing that. Now, it's not to say if we get another 5 years of a Labour government, maybe we can come up with something. And I can think of some ways in which it could be achieved, but it's not proposed here. And somebody also said in a session that I did, I can't remember where it was now, maybe it was at the TUC, said, well, you know, how are you going to guarantee that the unions are going to negotiate higher wages? And the answer is I can't. I mean, it's not possible. All that we can do as lawyers is to put forward proposals that would take effect in law that could provide the platform in which workers could achieve a better standard of living. It doesn't seem to me that legislation, and certainly not litigation, is a realistic way in which the condition of working class people's lives can be improved. Some agency staff, however, is something that is considered here, because the proposition of setting a minimum rate for the job, a minimum wage for the job, and the possibility of negotiating every conceivable form of terms and conditions, including the form of employment itself, offers the possibility that everybody will be included. So an agency worker under this system, we propose, will be paid exactly the same as a self-employed worker doing the same job, or a permanent employee doing the same job. Of course, it's not as crude as the national minimum wage or the national living wage, which just sets one hourly rate. We're proposing here that if one takes, electricians or something, there'll be a whole list of gradations of electricians. There'll be electricians on building sites, electricians on major civil engineering plants, electricians that work on the railways or in power stations, apprentice electricians, electricians that have got only grade level 4 or whatever it is. So that all these things will be negotiated with differential rates. But anybody who is at that level will get that rate regardless of what their form of employment is. Also proposing that the Ministry of Labour should have a strong labour inspectorate, like the health and safety inspectors used to be when they had the resources and the person power to inspect. We're proposing a substantial labour inspectorate will have the power to go into any workplace and say, I want to examine this woman's records to ensure that she's being paid properly. You say she is, let's prove it. So that's what we do think that enforcement is a key chapter in this book, how you enforce the rights that we're proposing that workers and trade unions should have. The crucial thing is to explain that what we're trying to do here. And when you think that there are 32.4 million workers in this country, it's an awful lot of the electorate who will stand to benefit from these proposals. And it defies common sense that the average ordinary worker is going to say, well, I don't like that very much, I'm going to vote Tory instead. I think that this is a sellable message. I see your point about the 1970s, of course, but of course, as you realise, that mythology of the 1979 and the winter of discontent was not about the miners or the railway workers or the dock workers. It was about poorly paid workers in the public sector who were repressed once again by a government-imposed wage freeze, who rebelled against it. And it's been portrayed as a terrible thing, but it's a myth. It wasn't so bad at the time. And the thing about the 1970s is that it's the most equal decade in British history ever in terms of disparity of wealth and income between the rich and the poor. It's something that we should be proud of, a decade that we should be proud of. But I agree, we've got to explain it in order that people can understand it. This offers the opportunity to work for working people to regain some self-respect by having an input into the terms and conditions on which they're employed. I hope you feel able to support this solution.
Thank you.